This voice thread is going to transition from libel to obscenity. Obscenity is one of the last areas of exception to First Amendment protections that we're going to look at. So after this, we will look at child pornography, and then there will be a couple of proposed areas of exception that haven't actually been accepted by the court, including depictions of cruelty to animals and violent video games. So in this voice thread, we're going to look at that tort that I mentioned in the last voice thread on freedom of the press. As you'll recall, libel is a civil tort, right? So this is a civil wrong that one private entity sues another private entity for committing. We're going to look at a related but different tort in this voice thread that is intentional infliction of emotional distress. All right, so you might think, well, it's not illegal to hurt somebody's feelings. Well, it's not illegal, but you can, in some circumstances, be sued for doing it, right? What this means is that you can be sued by the person whose feelings you have hurt under certain circumstances for compensatory damages, right? To kind of like correct the damage that you've done to them. So this isn't the same as it being kind of like illegal in the terms that, it's a criminal offense, but you can be held legally liable for damages that you do to people's emotional well-being. Surprise. So this is a tort. It's fairly limited. And it's especially limited, as we'll see when we look at Hustler Magazine versus Falwell, in its application to public figures. That said, it does apply to private figures. So the tort of intentional infliction of emotional distress, or as I'm going to be shortening it when it's written, IIED, is defined as the plaintiff acting abominably or outrageously with the intention of causing the defendant to suffer severe emotional distress. This is typically done by a defendant vocally issuing the threat of future harm to a plaintiff. Now, that also falls under like true threats, but this is a little bit broader than this. Right, so I'll post some cases on the discussion board, and you can decide whether or not you think they are intentional infliction of emotional distress. But often this is what we'll see with like cyberbullying cases, for instance. So it's a prima facie case, which is to say, like, this is something that's decided on its face. This isn't an in-application question. So here is what it generally looks like. The defendant or the person who's being sued acts. The defendant's conduct is considered outrageous. I mean, this is granted a subjective standard, but again, this is kind of a community standards kind of question. So the defendant acts with the intent, right, or for the purpose of causing the victim emotional distress, so severe that it could be expected, a reasonable person would expect it to adversely affect mental health. And then finally, that the conduct not only was intended to do that, but in fact does. So this tort is what's at issue in Hustler Magazine versus Falwell. So this case is from 1988, and this dealt with Jerry Falwell, who was a televangelist, right? So he was a very famous, like, megachurch TV preacher in the 1980s. And so Hustler was run by Larry Flynt. Hustler Magazine, it was an old pornographic magazine, basically, but it also featured some stories that were often like satirical and extremely crude. Larry Flynt was something of a First Amendment crusader, right? So he spent like most of his adult life in and out of court for obscenity charges, usually. In this case, Falwell brought him to court because Falwell sued Flynt, or Hustler Magazine, for intentional infliction of emotional distress. And so this dealt with a satirical story that Hustler ran. Well, I'll leave the facts to you to look at in your book. And so it dealt basically with this implication that Jerry Falwell had had sex with his own mother, right? I mean, in context, it was clearly, this was clearly satire, but Falwell got really angry about this, right? And he wanted Hustler to stop publishing things like this about him. And so since he couldn't really stop Flynt, what he did was take him to court and try to get damages out of him. So the initial suit was found in Falwell's favor and awarded him $150,000. So Falwell's attorneys challenged the action that Hustler took on the basis of falsity of the claim, right? And so Again, this was a satirical story about one's quote unquote first time that implied that Falwell had had sex with his mother. So Falwell's attorney said, look, this is obviously a false claim. And because this is so obviously a false claim and Hustler published it anyway, this is malice, right? This is actual malice. So what they were trying to do is reframe the actual malice standard from New York Times versus Sullivan to be something much easier to meet. So rather than saying, was there reckless disregard for the truth? Was there knowledge that the story wasn't true? Instead, they said, look, we should just be looking at the intention of inflicting harm through speech. So Falwell's attorneys also tried to move this definition of damages away from measurable damage in terms of income or reputation to emotional pain, right? So they're kind of trying to pull together the standard for libeling a public official with this tort of intentional infliction of emotional distress. The court does not find in Falwell's favor, right? They reaffirm the actual malice standard that they set in Sullivan. And in fact, the result of this case is that it's much more difficult for public figures also to sue for intentional infliction of emotional distress. One of the unintended consequences of Hustler versus Falwell is that some of the grounding for creating a hate speech exception was also eroded, right? So again, Falwell's attorneys used this reasoning that was focused on the intention of emotional pain, right? And this was something that kind of calls back to that language from Shaplinsky, remember? So Shaplinsky talks about fighting words, including words that by their very utterance, right, inflict pain or harm. And so the court, in Cohen had just kind of neglected that part and let it sort of wither away. But in Hustler versus Falwell, the court actually explicitly rejects that. So this ended up further eroding the foundations for a hate speech exception, reaffirming the actual malice standard in New York Times versus Sullivan, and also really limited the ability of public figures like Falwell, right, to sue for intentional infliction of emotional distress. This tort, intentional infliction of emotional distress, reappears in 2010 in Snyder versus Phelps. So your book covers this case in some detail, but this is the case in which the Westboro Baptist Church this is like one of many cases actually, but this is the one that went to the court, where the Westboro Baptist Church was picketing a funeral, right? So as this person, this person has died, his family is there mourning him, going through the memorial, and just, a few hundred yards away, there's the Westboro Baptist Church with their usual awful signs saying that this person deserved to die, that this is God's judgment, the usual sort of terrible things, right, that the Westboro Baptist Church says. And so there's a question of whether or not they could be sued for intentional infliction of emotional distress. And this seems like a fairly slam dunk case, right? Like clearly you have people acting outrageously in a way that was intended to cause, emotional suffering. And indeed that suffering was caused, right? If you look at the standards for intentional infliction of emotional distress, it seems like a slam dunk case. But in Snyder versus Phelps, the court reaches back to some of those cases that were decided right after New York Times versus Sullivan. And they say, look, in other circumstances, we have said that if this issue that's being discussed is of public interest, if it's an issue of public interest, then, we're not going to treat this like simply a conflict between two private parties, because suddenly now there's this political or public interest implicated. And so there need to be higher First Amendment protections for that. So looking at what the Westboro Baptist Church was actually objecting to in this case, they say, well, look, this is a criticism of the government. It's a criticism of the country. So there are issues of, substantial public interest implicated here. And so we are not going to treat this as if it were simply a tort being fought out between two private parties. And so they did not allow the family to sue the Westboro Baptist Church in that case for intentional infliction of emotional distress. So you can also, by the way, share your thoughts about Snyder versus Phelps on the board. The other important piece that comes out of Snyder versus Phelps is that the court again reiterates that there's a difference between making a true or false claim and simply engaging in political hyperbole, which is what they say the Westboro Baptist Church was doing in Snyder versus Phelps. All right, so this concludes our discussion of libel and of intentional infliction of emotional distress. We'll move now to obscenity. So obscenity is another area of speech that is not protected by the First Amendment. So there's a long history of obscenity law in the US, right, that we also, again, inherit from England. So the first question I want to ask is, number one, what is obscenity, right? Well, so this is generally treated as being forms of expression. So that can be depictions, it can be words, it can be video recordings, sometimes audio recordings that depict some sort of like quote unquote indecent or pornographic material. So one of the things that we see worked out in the cases is the difference between these different things. Like, so what is pornography? Well, pornography is depictions or descriptions of sexual activity. Okay, well then what is indecency? Well, that's like, there's a moral judgment going on there, but we aren't exactly sure what kinds of materials that applies to. What about information about birth control? Is that, it's obviously not pornographic, but is it indecent? It makes reference to sex. And then what's the difference between indecency and obscenity? So as we'll see, obscenity gradually evolves into being forms of communication or expression that are found to be lacking in sufficient social or political, artistic, literary value to merit any serious First Amendment protection. So this starts out being a very low bar, right, in terms of ruling something indecent or obscene, and over the years ends up being a very, very high bar. The Miller test is the test that we currently have for determining whether or not something is obscene for constitutional purposes, which is to say it's part of this category of exception and doesn't receive First Amendment protections. So the first kind of like precursor is Regina versus Hicklin. This is an 1868 case, way back there. Now, just as a sort of like indicator, whenever you see the word Regina appear, that means queen. So you're probably looking at a British case. So Regina versus Hicklin, this produced something that's similar to a bad tendency test. This is what the U.S. used, right? And this was reaffirmed in the 1870s, kind of stays in place in terms of, so in terms of a bad tendency, it just means, something that has the tendency to appeal to the depraved parts of a person's personality or tends to corrupt both adults and the youth, right? So this was a key part of the early obscenity standards, was that they, rather than taking the average adult as the person, who might be corrupted or have their morals damaged by exposure to this material, instead, they had this very low standard of it being potentially damaging to the youth. The next important case is Roth versus United States. And so this is the first test that is really articulated in the United States. So material that was, and I quote, calculated to debauch the minds and morals of those into whose hands it may fall, was found to be obscene. So this includes an average person standard, right? So inevitably these things are going to involve a certain amount of subjectivity. And in fact, this very famous line that we see from Justice Potter Stewart here at the bottom of the slide about knowing it when he sees it, that is very much the case for many of these obscenity cases, right? So identifying obscenity is very difficult, and creating a test for it was very difficult. It took about 100 years. So I'm going to turn now to Jacobellis versus Ohio and Memoirs versus Massachusetts. So these are the next sort of like stabs at creating a test or refining the test from Roth that the court took. So we see some narrowing here, right? So for one thing, Roth versus United States stepped away from the youth, right, or children being the standard for like who might be corrupted by exposure to this material, and at least moved it to then being, the average person, the average adult. Jacobellis versus Ohio and Memoirs versus Massachusetts further narrow that, right? So they introduce this, I think, this really interesting language, which is that the material has to be quote unquote worthless, right? Or utterly without redeeming social importance. Now, think about the very worst thing you have ever seen on the internet. Can you still say that it's utterly without redeeming social importance, right? So if you were the attorney who had to represent the maker of this terrible thing that you've seen on the internet, couldn't you come up with some argument for how it has at least some tiny shred of redeeming social importance? So the standard from Jacobellis and Memoirs is also very difficult to apply. But again, there's this famous line from Jacobellis where Potter Stewart says, "I shall not today attempt further to define the kinds of material I understand to be embraced within that shorthand description, which is, and I quote, hardcore pornography. And perhaps I could never succeed in intelligibly doing so, but I know it when I see it, and the motion picture involved in this case is not that." Ultimately, the court revisits obscenity in 1973 with Miller versus California. So this dealt with a mass mailing, right, that Marvin Miller sent out. And so it lands in the hands of this man and his mother. He opens his mail at breakfast in front of his mom, and lo and behold, here is a really pornographic, like explicit advertisement. So, and Miller ends up being charged under this and takes it to the Supreme Court using a First Amendment defense. So the issue here is California's indecency laws, right? So indecency and obscenity are not the same thing, right? So one of the things the court does in Miller is distinguish obscenity from pornography from indecency, right? So pornography is permissible, indecency permissible. Obscenity, the court says, is a very limited form of communication that does not have enough redeeming social value to be protected by the First Amendment. So we'll see some odd language in the Miller Standard, including the word prurient, right? So they'll say that, and this comes from earlier tests, right? You'll see this kind of evolve over the decades. But Merriam-Webster defines prurient as, and I quote, marked by or arousing an immoderate or unwholesome interest or desire, especially marked by arousing or appealing to sexual desire. Another important thing that we'll see change from the earlier cases is an application of the contemporary community standards test, basically. So the language of the Miller test includes judging the material by quote unquote contemporary community standards. Now, this is important because one of the things they do in Miller is narrow the definition of community to be the state. So whatever state law a person is being charged under for obscenity, that defines the contemporary community standard. Prior to this, the court had ruled that the community was national, right? So like little tiny, conservative towns in like rural Alabama would be bound by the same standards that applied in, say, like San Francisco or New York. So this gives a little bit more local control. Whether or not you think the state is sufficiently local, I will leave to you, right? So this case is dealing with California. Well, California is huge and internally very diverse. You could say the same thing about South Carolina, right? Are we using the same contemporary community standards in Charleston that are used in maybe smaller rural towns? I leave that, again, up to you, but what the court says the community standard is the state. The Miller test that ultimately emerges from Miller versus California has 3 prongs. And this is all going to look familiar if you've read the cases in the book. You'll see that a lot of this appears in earlier cases, right? So it's kind of pulling together different strands from earlier tests and abandoning other strands. All right, so the Miller test states whether the average person applying contemporary community standards would find that the work taken as a whole, this is important because it can't just be like one scene, or a few pages. The work taken as a whole appeals to the prurient interest. Okay. Second, whether the work depicts or describes in a patently offensive way sexual conduct or excretory functions specifically defined by applicable state law. And then finally, whether the work taken as a whole, again, lack serious literary, artistic, political, or scientific value. So what you may take away from this is it's really difficult to classify anything as obscene. Um, so I'm going to put a post on the discussion board that's going to seem sort of frivolous, but there have actually been cases in South Carolina about this. So are any of you familiar with, they're referred to as like quote unquote truck nuts. So these are replica bull testicles that they're made of plastic, and you can buy them, I don't know, I assume at like, I'm sure you can get them on Amazon if you want to, but people hang them from like the trailer hitch of their trucks. And so somebody asked, so someone actually in South Carolina was pulled over and ticketed for displaying these truck nuts. And so the question that ends up arising from this was, well, are they obscene, or is this a violation of her First Amendment rights? So I'm going to post a story about the case on the discussion board. It's from 2011. But apply the Miller test. Should truck nuts be legal? Are they a form of like protected First Amendment expression, or are they obscene? All right, so I'm going to leave you with that. We can discuss it further, next week on Thursday, or on the discussion board.